Not everyone who has a U.S. citizen child is going to be eligible for a green card when that child turns 21. If you enter the country with a tourist visa or any other type of visa or permit, then you may be eligible to file for adjustment of status, which can be a pretty short and straightforward process, and you attend your interview here in the U.S. However, if you enter the country without permission, it gets a lot more difficult. There are exceptions where you can still be eligible for adjustment of status even if you enter without permission, but not everyone is going to be eligible for those exceptions. And if you're not eligible to do adjustment of status, then you're going to have to leave the country for your interview at the U.S. consulate in your home country. But when you leave, there's going to be a 10-year bar if you've been living here without permission. And there's a waiver for that bar, but the waiver has to be based on hardship to your spouse who has status or your parents, not your children. So there are people that may have a U.S. citizen child can petition for them, but then they're not eligible for the waiver, and so they can't finish the process. In my office, we always do our best to dig and see if there's any way to have the person qualify for adjustment of status, even if they enter without permission. But sometimes there just isn't a way, unfortunately. But the only way to know for sure is to have a consultation with an experienced immigration attorney. I'm attorney Carla Casas. Like and follow for more videos on immigration law.